Well, good morning. This is Ian R. Crane. It's the morning of Monday, 4th of June, 2018. And I'm here at the Tinker Lane camp. Now, unfortunately, this camp probably isn't going to be physically in this location for too much longer. Only last week, request papers were submitted. By Nottinghamshire County Council asking the camp to vacate this location. And the next step, of course, is a formal a court notice of intent to evict. So we'll see. Obviously, the anti-fracking campaign is getting more and more experience in dealing with the courts over these type of situations. Now, for those who have been my morning updates, they will know that last week on Thursday and Friday, I was at the Manchester Civil Courts contesting Quadrilla's injunction. Now, I got to tell you that when we actually went to court on the Thursday morning, we went there in the hope that we were going to find that one of the local groups had actually contacted a legal team and had a legal representation with which to contest the Quadrilla injunction. And had that been the case, then we would have simply melded into the public gallery. Unfortunately, that wasn't the case. And once we actually got into the court, it was very apparent that basically, unless we submitted the skeleton argument that we had prepared over the previous few days, then Quadrilla would actually simply get their injunction rubber stamped. Now, the Judge Pelling, did acknowledge that we really hadn't had too much opportunity to establish legal counsel and to get a formal case put together. So he did agree that last week's hearing would simply be an interim hearing and that the full hearing would be set at a future date. Those dates we now know to be the 10th and 11th of July. So hopefully in the ensuing period, we can find proper legal representation to challenge Quadrilla's attempt to extend the injunction beyond the 11th of July, because what Judge Pelling has put in place is simply an interim injunction pending the full hearing in mid-July. So I'm pleased to say that Quadrilla didn't quite get everything that they had hoped for in the injunction, but it was very, very difficult to contest fully. And basically, that was made incredibly difficult because of public pronouncements of intended action. And because this is regarded as pretty much a direct threat, in this case, to the activities of the corporation, then it really is almost uncontestable. Now, I was putting forward the argument that, the key issue was proportionality. And when one takes into account the fact that this is an industry that was foisted on the community in the Fylde Peninsula, they had resisted it at every level up to and including Lancashire County Council, which of course famously rejected Quadrilla's application to frack at both Prestonwood Road and Rossiter I've lost track of days now. Is it 2 or maybe 3? I think it was 3 years ago. Yes, it must be 3 years ago, in 2015. And of course, that was appealed by Quadrilla, and it went to public inquiry, and Saeed Javid effectively instructed the inspector, the planning inspector, to not announce a decision, but to refer their findings to him. And Saeed Javid, of course, is a former board member of Deutsche Bank, and he was ostensibly put into the political arena in 2010 to push through the corporate agenda. So anyone who thinks that our serving Home Secretary is in office to serve the electorate just isn't paying attention. He is there to serve the corporations. That's what he was put in to do, and that is what he is doing. So, consequently, the decision of Lancashire County Council was overridden, and Saeed Javid effectively gave Quadrilla the go-ahead. Now, anyone who thinks that an industry can be foisted upon a community without that community putting up some resistance, then they are, of course, delusional. Unless, of course, we live in a corporatist state where any objection against corporate activities is fundamentally illegal. Well, that's the way it's heading, sadly. But let me make the observation. When one takes into account the opposition from the local community, I would certainly argue, and in fact I did try to argue last week, that the opposition to date has been proportionate. And in fact, Quadrilla's own documentation showed that from their perspective, the total number of lost operational hours as a result of protest activity was about 150 hours, which in the scheme of things is 6.5 days. And I quoted Mark Lappin, one of the Quadrilla directors, who in a public meeting stated, well, the delays caused by protests are irrelevant. Offshore, delays are caused by storms. Onshore, it's protests. So, here was prima facie evidence from Quadrilla themselves that the protest delay to date had been, in their opinion, ineffectual. However, the reason that this injunction was being sought was because of the success last year in terms of lost time as a result of the presence of Reclaim the Power. And because Reclaim the Power and others have posted pronouncements on social media stating that the period 11th of June to 1st of July is going to be one of significant protest activity, that was sufficient grounds for Quadrilla to seek the injunction and to effectively get it on the basis of the threat that was in the public domain, posted by a representative of Reclaim the Power and of United Resistance. Well, somebody was in the gallery from Reclaim the Power, and their observation was, well, we've always announced our intentions. We've done it since 2006. Well, this is perhaps time to change the strategy. And, I'm sure that whomever it was, I think it was Greenpeace, who orchestrated the protest in Paris at the AGM of Total, somehow I sense that they probably didn't post their intention to do that all over social media. So, we have to find ways maybe to go back to old methods of communication, like actually talking to each other, or writing letters, who knows. But the bottom line is that the moment that something such as a pronouncement of intended action appears on social media, then it is effectively gifting the establishment, and in this case Quadrilla, the opportunity to get an injunction put in place. So, the 10th and 11th of July is after this intended or pronounced period of actions. So we have another opportunity to go back to court and seek to get the injunction lifted. And one of the primary arguments, of course, will be proportionality, on the basis that it is a fundamental right of the local community to participate in peaceful protest. And of course, the argument then comes down to what constitutes peaceful protest and what constitutes proportionality under Articles 10 and 11 of the European Human Rights Convention. Well, it's not necessarily going to be an easy argument, but one of the observations that I made to Judge Pelling last week is that with these injunctions, and of course this is the third injunction that Quadrilla have sought, the first being in October 2014. Second one last March, where they tried to corral the protest into a protest pen, which we successfully challenged. And now here we go again. And of course, we have the INEOS injunction being challenged by Joe Corrie and Joe Boyd, who have both managed to get the Royal Court of Appeal to acknowledge that there are elements within Justice Morgan's ruling that actually are worthy of appeal. And now we have UCOG, and they have a substantive hearing scheduled in London, I believe, for the 2nd of July. So the observation I made to Judge Pelling is that at the moment, this is an anti-fracking campaign. But with the propensity of the industry to seek injunctions against peaceful protest, the establishment are in grave danger of escalating the campaign from anti-fracking to civil rights. Because what we are witnessing is an erosion of those civil rights, and certainly an erosion of the right to peaceful protest, the right to oppose an agenda where people have done their research and are simply not prepared to roll over and allow a destructive industry to roll into their community. Now, it goes perhaps even beyond that, because, you know what, and again, I did make this observation to Justice Pelling, that what we are looking at here is TTIP, the Transatlantic Trade and Investment Partnership, effectively being introduced through the back door of the courts. And, you know, therefore, we are in grave danger of the illusion of democracy literally evaporating, and people seeing firsthand that we are in a fully fledged corporatocracy where the corporations are able to establish a raft of supra-parliamentary legislation through the courts. And if that is the case, if that is what manifests as a result of these injunctions, then it shouldn't be any surprise that people from other campaigns join the anti-fracking community in a bid to retain the hard-fought for civil rights that we all hold dear. Not least, of course, Articles 10 and 11, you know, the fundamental right to assembly, the fundamental right to free speech, and of course the fundamental right to peaceful protest. And, you know, I quoted the parliamentary subcommittee's recommendations from 2009 on interpretation of the human rights legislation, which states quite clearly that protest may result in nuisance and disruption. And when considering applications for injunctions, it is beholden upon the courts to determine what is proportional in terms of nuisance and disruption. And by Quadrilla's own admission in court last week, their idea of nuisance and disruption is basically zero. So their interpretation of peaceful protest is effectively the US-style free speech zones, of course, which they tried to establish last year with the protest pen, where you can stand in a designated area and you can wave a placard or shout all you like, but not cause any disruption to the activities of the corporation. And of course, if TTIP ever does or become established, then there's a whole raft of companies, and of course INEOS are trying to preempt this in Scotland by threatening to sue the Scottish government for preventing them from fracking across the central belt of Scotland. And there's a Texan company that's basically waiting to sue the French government for preventing them from fracking in France. So this is a potentially escalating situation. And, you know, I hope that people will take a look at what's occurring here and understand that the anti-fracking campaign is very much on the front line of the protection of the civil rights in this country. And here, the few people that have established a presence at Tinker Lane are basically on rig watch because here in North Nottinghamshire, where for whatever reason it seems to be extremely difficult to get the local population to understand or even research the magnitude of the threat that this industry brings to their community. And of course, we are in the heart of the old coal mining area. And of course, once again, I make a reference to the report produced by Professor Peter Stiles, which effectively lays out the magnitude of the risk associated with fracking beneath the extensively mined areas in the north of England, which, funnily enough, is pretty much everywhere under the Bowland Shale. So, in the short term, if you have the opportunity to visit Preston New Road, please do be mindful of the injunction. And on Fracking Nightmare this coming Thursday night, I will go into detail of the injunction. Now, I have heard that there is one legal advisory group that is advising people not to share the injunction because a defense is that you weren't aware of the injunction. Frankly, I find that advice absolutely absurd and indeed somewhat immoral, because if somebody is aware of that injunction, then in my opinion, they have a moral duty to make sure that anyone they know who is considering an action within the injuncted area or an action which breaches the injunction, and thereby that person is putting their assets or even their liberty at risk, then you have a responsibility to advise them to do that. Now, if somebody wants to do an action within the injuncted area and is fully aware of the potential implications, then, well, that's their choice. That is their freedom to choose that. But it is absolutely essential that people do familiarise themselves with the terms of the injunction, which are that the area from Peel Hill, which is just north of the B&Q roundabout on Preston New Road, to 50 metres southeast of the Bellmouth, of the Quadrilla Bellmouth, that area is injuncted. So any action taking place in that stretch of Preston New Road, which is targeted at Quadrilla and causes Quadrilla loss or harm, then it is covered by the injunction. So that's a very, very clearly defined area from Peel Hill, that's Peel, P-E-E-L, Hill, northwest of the B&Q roundabout to 50 metres southeast of the Bellmouth. Now, the injunction also covers third-party suppliers, but only if the action at the third-party suppliers is targeting Quadrilla. And the onus is on Quadrilla to prove in any attempt to enforce that injunction that the action is intended to cause Quadrilla loss. So that's the basic premise. But, please, if you do want more information, then please you feel free to contact me, to contact Benjamin Dean or Helen Chunso. And if you're on the file, contact Bob Dennett or Darren Dennett or Tom Burke, my fellow defendants in the case last week. So that's it from me today. I'm going to be here at Tinker Lane until probably early afternoon. It really does need more people here. There is ongoing observation at Marriott's because the permission that IGAS have sought is for one of two rigs, either the H220 drill mech rig, which would come probably from Marriott's, or the drill tech rig, which would most probably come over from Germany. And that rig and the associated infrastructure is most probably going to arrive here at Tinker Lane in the not too distant future. So thanks to those people who have come to visit the camp at Misson Springs, and to those people who have made considerable effort to travel some distance to come here and support the community at Tinker Lane. So it's cooled down a bit today from the heat wave of yesterday, but at least it's not raining yet. So I will catch with you tomorrow morning at 8:30. You take care now.